Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. In the recent case of Motortrack v FCA Australia, FCA Australia terminated Motortrack's contract for marketing services several years early. Motortrack then sued for the profits it would have earned to the end of the contract, but FCA Australia successfully dodged any liability as it relied on the widely worded exclusion of liability clause that excluded any liability for loss of profits. This case again shows the courts will enforce the literal words of the contract, even where this leaves a party with no effective remedy for a contractual breach. A little delayed and watered down from Theresa May's planned reforms to corporate governance, but new draft laws, subject to parliamentary approval, will apply for financial years on or after the 1st of January 2019. The reforms mostly require new disclosures in the annual returns. The changes only impact large businesses, and the disclosures then differ depending on whether the business is large or very large, the number of employees, and whether it is quoted on certain markets. The disclosures include statements on how the directors have engaged with the employees, had regard to their interests and the effect of doing so. And certain quoted companies must publish information on the CEO pay ratio to the average employee and how the director's pay is linked to the future share price growth. Commercial contracts do not usually have any implied duty of good faith. However, a recent case has upheld previous decisions that a duty of good faith may be implied into relational contracts. Relational contracts are contracts where the parties collaborate and often stem from circumstances where friends have become business partners and entered into a joint venture as equal business partners. The judge in this case held that in these circumstances, each party should be able to trust that the other party will act with integrity and in the spirit of cooperation. Earlier than planned, but new regulations came into force in April to make it easier to remove home address information about directors, secretaries and people with significant control from the Companies House public records. Although new directors have been able to keep their personal addresses private since 2009, until now it has not been possible to remove historic information. In recent weeks, the Supreme Court decision in the Pimlico Plumbers and the Employment Appeal Tribunal decision in Addison Lee have been published. Both decisions have followed the trend of similar cases ruling that individuals were workers rather than being self-employed and therefore entitled to the benefits of worker status, including the right to holiday pay and to stop unlawful deductions from wages. Control has been a key issue. If an employer exercises control over the individual by certain standards, such as requiring a uniform or colour of vehicle, then this is likely to point towards the person being a worker rather than self-employed. Whether the person can refuse jobs or provide a substitute will also be important, but note that in Pimlico, an unwritten right to substitute to another employee or contractor was not sufficient to prove it was a self-employed contract. In Addison Lee, an express right to refuse jobs also did not persuade the tribunal that it was a self-employed contract, particularly when it was noted that there was subtle pressure on the riders to accept jobs. The recent Employment Appeal Tribunal case in Rhodes v Sheffield Hallam University has overturned an earlier tribunal decision and confirmed that zero-hour workers are entitled to compare themselves to full-time colleagues and bring claims for less favourable treatment. In the recent case of City of York Council v Grosset, the Court of Appeal upheld the decision that an employer was liable for discrimination arising from a disability, even though it was not aware that the employee's actions were due to their disability. The government has launched a consultation on the IR35 rules for the private sector. The IR35 rules are designed to ensure that individuals that provide services through an intermediary usually a personal services company, but would have otherwise been an employee, pay the same PAYE and NICs. The responsibility for this rests with the intermediary, but the government believes that this is not an effective control and that only 10% of those who should comply with IR35 rules do so. The government's favoured position seems to be to move to similar rules that already apply in the public sector, where the public sector employer is responsible for determining whether IR35 applies and for paying the tax and NICs if it does. The consultation process closes on the 10th of August. It's now 2 years since Hillgate, when Nicola Thorpe's story of being sent home for not complying with her employer's policy of high heels for women. The government decided that new laws were not needed as it felt existing laws already adequately dealt with such discrimination. New government guidance on workplace dress codes has, however, now been published and is available on the government website. The guidance states that dress codes should apply equivalent standards, but this does not mean exactly the same for both sexes. It also covers guidance on dealing with dress codes for transgender staff and on religious symbols. The Supreme Court has ruled that trademark owners must pay the costs of implementing a court order to require UK internet service providers, ISPs, to block access to websites selling counterfeit goods. This reverses the previous decisions that had made the ISPs liable for the costs and is at odds with decisions made in some other European countries. On the 9th of June, the UK Trade Secrets Regulations of 2018 came into force. The new regulations implement the EU Trade Secrets Directive. The directive sets a minimum legal standard for trade secrets across the EU. Now, it is mostly consistent with case law in the UK, so nothing materially is changing. It's arguable that regulations create a higher bar for businesses to substantiate whether something is a trade secret, as it requires the businesses to show it has taken reasonable steps to keep the information secret. Accordingly, where a company wants to ensure that information is kept secret, it should at least use non-disclosure agreements. The Supreme Court has ruled that trademark owners must pay the costs of implementing a court order to require UK internet service providers, ISPs, to block access to websites selling counterfeit goods. This reverses the previous decisions that had made the ISPs liable for the costs and is at odds with decisions made in some other European countries. On the 9th of June, the UK Trade Secrets Regulations of 2018 came into force. The new regulations implement the EU Trade Secrets Directive. The directive sets a minimum legal standard for trade secrets across the EU. Now, it is mostly consistent with case law in the UK, so nothing materially is changing. It's arguable that regulations create a higher bar for businesses to substantiate whether something is a trade secret, as it requires the businesses to show it has taken reasonable steps to keep the information secret. Accordingly, where a company wants to ensure that information is kept secret, it should at least use non-disclosure agreements. Thank you for tuning in for this month's commercial bulletin. For more information on any of these stories, please don't hesitate to contact me at Radius Law. We'll be back in August with more of the month's key legal updates.